The Presidential Election Petition Court, hearing the case of the People's Democratic Party, PDP, and Atiku Abubakar, is at its most crucial stage. Documentary evidence have been submitted, running into thousands of copies of materials used for the February 23, 2019 presidential election. Issues have been joined by the parties, and witnesses have been called by both the petitioners and the second respondent, Muhammadu Buhari. On the 1st of August, after the second respondent abruptly closed its defense, and the third respondent, the All Progressives Congress APC, opted not to furnish any defense to the issues raised by the petitioners. The chairman of the Election Petition Court, Justice Muhammad Garba, ruled for an adjournment to enable the parties file and exchange their written addresses.
Given the events of the last 2 days in this court, it was obvious that they couldn't continue to take the gamble of calling witnesses who, rather than improving their cases, were rather damaging their cases beyond redemption. So they had to cut their losses. I assure you that this case, I hope so, will define electoral jurisprudence in this country one way or the other. Thank you.
It is better to retreat when you have been beaten to a pulp. Then you surrender. What we saw today was an act of surrender. For example, the APC said they were closing their case. You don't close a case that you have not even opened. We were expecting them to open their case, but they closed their case when they had not opened. One thing they must know is that this case, apart from defining our laws and legal jurisprudence, is also in the public domain. The whole world is watching. They want to see how the electoral process in Nigeria works. The whole world is interested in knowing what happened on the 23rd of February 2019 when the presidential election took place. The whole world wants to know whether Nigeria is actually advancing in constitutional democracy or is actually retreating into the Hobbesian state of nature where life was short, nasty, and brutish. It is well with Nigeria. We believe that justice will be done. Justice will be served, and by the grace of God, Nigerians will be happy.
I've not made out a case for them to refute. That's just the import.
The three respondents were the first to file their addresses, which are a comprehensive detail of written argument in support of the defense and objections to the petition filed by Atiku and the PDP. On the 16th of August, the petitioners filed their reply to each of the addresses. In the reply to the address filed by the Independent National Electoral Commission, INEC, the PDP relisted the issues for determination. These are whether the second respondent, Muhammadu Buhari, was at the time of the election qualified to contest, whether the second respondent submitted to the first respondent, INEC, affidavits containing false information of a fundamental nature in aid of his qualification for the said election, whether by the pleadings and evidence it was established that the second respondent, Muhammadu Buhari, was duly elected by a majority of lawful votes cast at the election, whether the presidential election conducted by INEC was invalid by reason of corrupt practices, and finally, whether the presidential election conducted by INEC was invalid by reason of non-compliance with the Electoral Act 2010 and the Electoral Guidelines and Manuals 2019 issued for the conduct of the elections. On issue 1 and 2, which deals with the qualification of the second respondent to contest, the petitioners in their written address argued that Buhari did not possess the certificate he claimed in his INEC form CF-001. The certificates listed by Buhari include First School Leaving Certificate, West African School Certificate, and Officer Cadet Certificate. However, it was noted that none of the certificates were attached to the INEC form CF001 marked as Exhibit P1 by the court. In view of this, the petitioners contend that Buhari did not satisfy the mandatory requirements of Section 131 sub D of the 1999 Nigerian Constitution as amended. That section provides that, quote, a person shall be qualified for election to the office of president if he has been educated up to at least school certificate level or its equivalent. The definition section in Section 318 sub 1 of the Constitution explains a school certificate or its equivalent to mean a secondary school certificate or its equivalent, or Grade 2 teacher's certificate, the City and Girls certificate, or b education up to secondary school certificate level, or c primary school certificate or its equivalent, and service in the public or private sector in the Federation in any capacity acceptable to the Independent National Electoral Commission for a minimum of 10 years, and attendance of courses and training in such institutions as may be acceptable to INEC for periods totaling up to a minimum of 1 year, and the ability to read, write, understand, and communicate in the English language to the satisfaction of the Independent National Electoral Commission, and any other qualification acceptable by the Independent National Electoral Commission. In the legal arguments submitted by the petitioners, the contention is that there are 4 paths to educational qualification under Section 318 sub 1 of the Nigerian Constitution, and every candidate must choose which to rely upon, which could be either secondary school certificate education to secondary school level, primary school leaving certificate, or any other qualification acceptable by INEC, or all the 4. In Buhari's case, according to Exhibit P1, Buhari chose only secondary school certificate and primary school certificate, listing the schools he attended and the qualifications obtained to include primary school certificate, WASC, and officer cadet. The petitioners in their address have argued that to be qualified, Buhari must produce his primary school or secondary school certificate or officer cadet, since those were the qualifications he claimed in his form CF001. They have asked the tribunal to dismiss all the other evidence submitted by Buhari to prove his qualification, including that claim that he can't communicate in English, as irrelevant because he only relied on secondary and primary school certificate and officer cadet qualification. In the address, they have referred to Buhari's affidavit wherein he swore that his certificates were with the Army Board, but wondered why, as the Commander-in-Chief of the Armed Forces, he could not obtain copies of it for production in court. To this end, the petitioners in the address before the Election Petition Court have also indicated that Buhari submitted false information of a fundamental nature by referring to the evidence of the president's witness, retired Major General Paul Tarfa, who told the court that enlisted officers did not submit their academic credentials to the Army Board. Their argument being that as the C-in-C, he was in a position to command the Secretary of the Army Board to produce his certificate and ensure his compliance, instead of going all the way to Cambridge in the United Kingdom to obtain what they describe as a bogus document, which his own witness admitted was not a certificate, citing the testimonies of the Chief of Staff, Abba Kyari, and the WAEC official.
The evidence of their own witness, General Tafa, who was a classmate of President Buhari, and who in very clear and unequivocal language said that he and the president never, contrary to the president's case, never submitted any certificates to the military, confirming the stand of the military. And that is our case.
has been our case.
So their own witness confirmed our own case. So what is left?
The issue is that from the documents they have presented, don't you believe that he has certificates? That's all. If I have certificates, even if I hide it under my bedroom and decide to bring it tomorrow, it's not my certificate. What type? How can you say it's contradiction? With the Cambridge certificate he presented, exhibit PR28, did you not see it? Was it not read? He had 5 credits. That's how high I can go.
The petitioners also challenged INEC's neutrality. And on INEC's refusal to call witnesses or produce any evidence, the petitioner cites the authority of Akimbade versus Babatunde, reported in 2018, wherein the Supreme Court held, quote, "The principle remains that mere averment without evidence in proof of pleaded facts go to no issue. The lower court, therefore, is right in finding that the plaintiffs appellant who have failed to lead evidence in proof of their pleadings on the source of their title to the land in dispute on the authorities must be deemed to have abandoned their claims." The PDP and Atiku want INEC to convince the court how and why it found Buhari's alleged qualification acceptable, and that INEC cannot treat the court as a rubber stamp by merely filing an address without furnishing the court with pleaded fact. On issue 3, which has to do with whether Buhari scored the highest number of lawful votes cast at the election, the petitioners in their written address refer to a litany of authorities to argue that in the resolution of election dispute, it is normal to cancel and set aside a return of a candidate who did not score the majority of lawful votes. On this issue, the petitioners have invited the court to examine the evidence laid on the votes in the INEC server, imputed through the smart card reader, and the analysis of votes and results obtained as reflected in the certified true copy of forms EC8A, Bs and Cs in the 11 focal states in contention. According to them, the victory margin from the analysis of the results shows 1.9 million votes in favor of the petitioners. Thus, they say, is further established by the evidence led by the RATEX and the fact that INEC did not lead any contrary evidence of its own. The address further restates the position of INEC on the sanctity of the use of the card reader as well as analysis of the computation errors in the forms. On issues 4 and 5, where corrupt practices were alleged, the petitioner's written address lists particulars of such which include massive multiple thumbprinting, manipulation of election materials and card readers, arbitrary arrest and detention of supporters of the petitioners, and manipulation by security agencies, among others. They have contended that all the votes purportedly cast for Buhari are wasted votes, as he was not qualified. Neither did he prove his qualification before the court. In conclusion, the petitioners have urged the court to declare Atiku Abubakar winner of the election, or, in the alternative, annul the February 23, 2019 polls and order a fresh election. Wednesday, August 21, will be the day the Court of Appeal, sitting as a presidential election petition court, will entertain argument on the written addresses submitted by the parties.